next case to come before the court is State of Ohio v. Stanley Ford. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal, and if you do plan to reserve time, please let me know, as I will be keeping track of the time. The arguments are being recorded, so please stay behind the podium and keep your voices up. You should not use the names of children, minors, and victims during your argument. You can refer to them by initials or terms like a child. The judges have read your briefs and are ready to proceed when you are. And would you like to reserve time for rebuttal?
Yes, Your Honor. 3 minutes, if I may.
You may proceed when you're ready.
Good morning. May it please the court. My name is Victoria Bader, and I'm counsel for appellant Stanley Ford. Stanley Ford was sentenced to life without parole following a capital trial that joined charges arising from 3 separate incidents. In his brief, Mr. Ford assigned error to numerous pre-trial and trial-related issues, most of which he requests reversal and remand for. Today, I plan to focus my time on the issues related to competence and failure to suppress Mr. Ford's interrogation, but I'm happy to answer any other questions that the court has about the other assignments of error. Regarding competence requires that a defendant is both capable of understanding the nature and objective of the proceedings against him and of assisting in his own defense. During pretrial litigation, the trial court itself sua sponte ordered a competency evaluation, specifically citing concerns as to whether Mr. Ford's cognitive impairments and beliefs of conspiracies prevented him from assisting in his own defense. Dr. Wood of the court's diagnostic clinic met with Mr. Ford multiple times and spent a total of 5 hours with him. She also reviewed significant collateral information, including neurological evaluations, neuropsych reports, psychiatric records, Mr. Ford's pro se motions, trial court transcripts, and medical, jail, and juvenile court records. In her report, she raised concerns about Mr. Ford's potentially delusional comments. Those included that his attorneys were conspiring against him, that the judge and prosecutors were making hand signals to each other in court, and that God was talking to him. She also noted that his inability to remain focused on specific topics may interfere with his ability to assist in his own defense. She did determine that Mr. Ford had the ability to understand the nature and objectives of the proceedings, but she was unable to make a determination on whether he could assist in his own defense, and therefore referred Mr. Ford to Twin Valley for a 20-day inpatient evaluation. After that evaluation, Dr. Edwards from Twin Valley testified at a competency hearing, and he testified that he believed that Mr. Ford was competent to stand trial. But his opinion regarding delusions was based solely on 10 to 15 minutes of evaluating Mr. Ford, even though his delusions were the exact reason that Mr. Ford was referred to Twin Valley in the first place. Despite his consistent and pervasive beliefs regarding conspiracies that can be found in his in-court statements, his pro se motions, jail calls, and statements that he made to both Dr. Wood and a prior neuropsychologist, Dr. Edwards quickly dismissed of the possibility of delusions after 10 to 15 minutes because Mr. Ford acknowledged that he would change his mind if other facts were available. Dr. Edwards also acknowledged that he failed to review a significant amount of collateral information that was provided to him. He did not review a very thorough neuropsych report that included significant testing. He didn't review treatment records from Mr. Ford's prior psychiatrist. He didn't review active medical records, DYS records, juvenile court records, or court transcripts. He acknowledged that he was unaware that these collateral records existed, and he also admitted that some of the historical information he provided in his report was inaccurate as a result. He testified that he wished he had access to that collateral information, and that he would take that lesson as education. But he reiterated that his conclusion regarding competency would not have changed, even though he did not know the full scope of what was contained in those collateral records. For these reasons, Mr. Edwards...
Counsel, can you expand a little bit on that? I seem to recall reading in one of the briefs that he actually said because there was a snapshot in time. Is that why the opinion wouldn't have changed?
I'm sorry.
The determination of competency is a certain snapshot in time. Is that correct?
It is. Competency is competence at the time of trial, and so it's contemporaneous with the evaluation. Certainly, prior statements from Mr. Ford about delusions. However, Dr. Edwards testified that during his time in talking to Mr. Ford, that 2-hour and 15-minute interview that he had with him, that they only spent 15 minutes discussing delusions, that Mr. Ford did not express any delusions to him at that time. He also testified that the other evaluators during his time at Twin Valley didn't notice anything either. And so from Dr. Edwards' snapshot of the limited time that he spent with Mr. Ford, he did not notice any delusions. But what's important to note here is that Mr. Ford was evaluated twice by 2 separate psychologists. Dr. Wood spoke to him for more than 5 hours, and based on her review of the records that Dr. Edwards didn't review, and her conversations with him, she was unable to reach a determination because she also noticed the delusions, the conspiracies, the things that Mr. Ford had expressed to the court and to other evaluators. And so the fact that this didn't appear during Dr. Edwards' evaluation, one, is potentially a symptom of the fact that sometimes delusions require triggers. He was there for 20 days, but the concept of delusions was only discussed for 15 minutes, and it was very quickly disposed of, just solely based on the fact that Mr. Ford said if somebody gave, well, he didn't say, he agreed that if somebody gave him alternate facts, alternate evidence, that he would be willing to consider it. However, Dr. Edwards did also acknowledge that he didn't ask Mr. Ford to engage in any sort of exercise to explain what types of alternate facts or what circumstances that he would be willing to consider and accept alternate facts and theories.
Thank you so much, counsel. I have another question. Was there a request, a motion for a second evaluation?
There was a request for a defense evaluation.
Okay, and was that motion granted?
That motion was granted, and that never ended up in the record, so that the outcome of that is not a part of this record.
Okay. It was withdrawn, correct?
That is correct, Your Honor.
Thank you.
So based on the things that I've discussed, Dr. Edwards' competency finding is unreliable, and as a result, the trial court abused in its discretion when it relied on Dr. Edwards' competency evaluation to make the competency determination in this case. I'd like to move on to suppression. It's well established that once an individual invokes his right to counsel during a custodial interrogation, he is not subject to any further interrogation until either 1, counsel is made available to him, or 2, he himself reinitiates with the police. There are no specific words necessary to invoke one's right to counsel. Instead, all that's required is some statement that can be reasonably construed as a desire for counsel, such that a reasonable officer would understand. Once that request is made, officers must scrupulously honor that request in order to prevent police from badgering a defendant into waiving his previously asserted rights. So the question in this case is, first, did Mr. Ford invoke his right to counsel? And second, if he did he reinitiate communication with the police? Regarding his request for counsel, the trial court found that his statements were not an unequivocal request, but that was not supported by the record in this case. Within minutes of being Mirandized, Mr. Ford stopped the interrogation and asked for counsel 4 times. He said, "Let's hold it, I'd rather have counsel now. I'd just rather have counsel now. No, I'd rather have counsel now because you're accusing me of something I didn't do. I'd rather talk to counsel now." While the court and the state assert that the phrase, "I'd rather have counsel now," is not an unequivocal request for counsel, the analysis is unnecessary in this case because Detective Looney, the detective who performed the interrogation, a reasonable police officer testified himself at trial that Mr. Ford actually did request counsel. And Detective Looney viewed that request as a request for counsel, which is why he was so adamant about ensuring that Mr. Ford was re-Mirandized before continuing the interrogation. For those reasons, his statement was an unequivocal request. The trial court also incorrectly found that Mr. Ford reinitiated communication with the police. It was impossible for Mr. Ford to reinitiate contact when the police never ceased the interrogation to begin with. After each of his numerous requests for counsel, the detectives, not Mr. Ford, followed up. First, they stated, "Well, if at any time you choose to talk to us," and asked him if he had their card. Another detective said, explain his charges to him, and they attempted to explain his charges. They stated, "I really want to talk to you, but I can't unless you want to talk." Mr. Ford responded, "No." They said, "If you talk to us, I'll reread you your rights again." Mr. Ford responded, "I'd rather have counsel now." And that continued until detectives, without Mr. Ford's request, re-Mirandized him. This is the exact scenario that Miranda and other United States Supreme Court precedents sought to prevent. Detectives here knew that Mr. Ford had requested counsel, and rather than scrupulously honoring that request, they continued to urge him to talk in an attempt to overcome his prior assertion of his right to counsel. The trial court incorrectly held that Mr. Ford's statements were not unequivocal and that he personally reinitiated. And as a result, this court should reverse the lower court's decision and remand for a new trial without the use of his interrogation.
What specific statements did Ford make?
So there was no full confession here. There were statements, he made statements, if I was outside, they continued pushing him, asking more questions like you would see in an interrogation, and he said, okay, well, if I was outside, then I didn't see a fire. He said, well, when I was outside, he talked about the fact that he was outside at a specific time to collect lemon balm for tea. He made statements that if anyone were coming in and out of the side door of his house, that it would have been him. And so those are the statements that he made, and I certainly recognize this isn't a confession, right, but these are the statements that the state used in closing, very heavily in closing, to tell the jury, look at the statements Mr. Ford made. Look at the things he said. They said that's an admission. When he says, if I was out walking down Phillips, the street in his neighborhood, that's an admission. They urged the jury to go back, to look at the statements he made, to find contradictions in the statements he made, and to use his assertions that if he was outside, or if anyone was coming in his door, it was him, as evidence that he truly was outside the night of the fire. And so that's the issue in this case, is the fact that the jury heard all of that, it should not have come in, and then the state heavily relied on it in closing and urged the jury to look at that information. If there are no further questions on these assignments, I'll reserve the remainder of my time.
Thank you.
Thank you.
May it please the court, Evan DiMartino on behalf of the state of Ohio, the appellee. The state is asking that this court affirm Mr. Ford's convictions for the arson-related deaths of 9 individuals, including 4 adults and 5 children, who ranged in age from 14 years of age to 1 year of age. The state is asking that this court affirm Mr. Ford's convictions because 1, he was competent to stand trial. 2, the trial court did not err in allowing 1 trial for the 3 arson-related incidents, which was a house fire, a vehicle fire, and then another house fire, all within a very short distance from Mr. Ford, all involving his neighbors that he had had a argument or some type of disagreement with prior to the fires. There was no prosecutorial misconduct in this case. The trial court did not err in allowing forensic specialist with the fire marshal's office, Mr. Barkhart, to testify and use a presentation that he compiled of his investigation, which was very voluminous, as well as a timeline for each of the 2 house fires. And finally, the trial court in this case did not err when it declined to suppress Ford's statements. With regard to the first assignment of error regarding competency, the Ohio Revised Code sets forth the standard for competency in Ohio. A defendant is presumed to be competent under 2945-37G, and then as articulated by opposing counsel, the competency test is that the defendant must have the present ability at the time of the trial to consult with their lawyer and then have a degree of understanding of the proceedings, the things that are going on in court. In this case, there was a hearing, and I know that there was supplemental authority filed in State v. Huff, which is a Supreme Court case from Ohio, that recently came out that said if there is an issue with competency raised before trial, there should be a hearing. There was a hearing in that case. That case did talk about how the trial court, if they do not have a hearing, but they look at an indication of the defendant not having competency and they just rule on it without a hearing, that is an issue. But the Supreme Court did not say if a trial court asks for a competency evaluation, looks at the competency evaluations, and then comes to a conclusion based on the hearing and the evidence before it, that there is an error. So in this case, it is correct that the judge had some concerns about Mr. Ford's competency during a hearing on the motion to dismiss the death penalty specifications, and the matter was referred to psychodiagnostic clinic where Dr. Woods did complete her evaluation and was unable to render an opinion. That was then referred to Twin Valley, where Mr. Ford stayed for 20 days, where he was evaluated for 24 hours a day. Dr. Edwards looked at the reports of the folks who saw Mr. Ford at the facility. He interviewed Mr. Ford, and then he issued his his expert opinion. With regard to the defense request for a second opinion, that is in the record because it is in the journal entry that was filed on January 14th, 2020. So the court was aware that the defense had asked for a second opinion and that the court had granted that and that the defense had withdrawn it. The defendant nonetheless went forward with a competency hearing on December 19th, 2019, where Dr. Edwards testified. There's nothing in the record that would show that the trial court abused its discretion in its analysis of the information before it, which included the report of Dr. Wood. So regardless of whether Dr. Edwards considered Dr. Wood's report, the court did. The court also considered Dr. Edwards' report. The court also had this case, it's a 2017 6 case, which means that at that point the court had this matter before it for almost 2 years. So the court was familiar also with how Mr. Ford behaved in court, in addition to the medical professionals' opinions that were before the court. Dr. Edwards clearly and unequivocally stated that the additional information would not have changed his mind, and he stood firm in that belief. That's on page 106 and 107 of the competency hearing transcript. It is Dr. Edwards that is the expert in competency. It is not for the defense to just simply disagree with what Dr. Edwards concluded based on his interviews, based on what the service providers observed for 20 hours a day, 24 hours a day, based on Dr. Wood's report, which does have also a summary of Dr. Oswell's report. So the fact that they disagree with the expert's conclusion does not show that the trial court abuses discretion. So the standard would be, was the court unreasonable, arbitrary, or unconscionable in the court's conclusion that Mr. Ford was competent to stand trial? And that burden has not been met in this case. There was no evidence in the record to contradict the findings of Dr. Edwards.
Well, that because it seems to me what the appellant's argument is that Dr. Edwards spent so little time talking about delusion that we shouldn't give much weight to his opinion in this case.
Right. Well, there's nothing in the record to support that Mr. Ford is delusional. And Dr. Edwards only said that he discussed specifically delusions with regard to his opinion about his attorneys being against him for 10 to 15 minutes. And he did that because there was nothing there. But that was based on all of the information that he had before him, which would include the observations by the Twin Valley staff the entire time. So there was no evidence in 20 days of delusion. And while it's not in the record, there certainly is an understanding that when it comes to mental health issues, that some people are able to, act certain ways for a certain period of time, when maybe that's not truly indicative of their mental health. So in this case, he was observed for that long period of time, 20 days, 24 hours a day, and Twin Valley staff did not see or display significant symptoms of mental illness or cognitive disorder. That's on page 15 and page 81 of the competency hearing transcript. So it's up to the medical professional to decide how much time to allot to each allegation. If there's no evidence to support delusions, specifically as to whether or not counsel was out to get him, there's nothing in the record that would show that that decision was wrong or that it made the trial court's decision to find Mr. Ford competent to the level of an abuse of discretion. So based on that, the state would ask that the court overrule the first assignment of error. With regard to the second assignment of error, in this case, there were 3 arsons, like I said.
Counsel, not to take you out of order, but if you could move to the issue of suppression.
Sure. So with regard to the suppression issue, the state would argue that the trial court did not committed error when it declined to suppress Ford's statements. At the outset, the state would also argue that if there was error, it was harmless error. As pointed out, the statements were not a confession. They were more exactly what co-counsel said as far as if I was outside. But with regard to the invocation of the right to counsel, the state would argue that this court doesn't have to get to the issue of whether or not there was a proper invocation of the right to silence, to counsel, that whether it was unequivocal or unambiguous, because the police officers found that it was, and they stopped questioning. If the court does get to that issue, the state would argue that there was not an unequivocal and unambiguous request for counsel. His statement was, I would rather have counsel now, and rather indicates a preference, not an unequivocal assertion of the right to counsel. There's case law that talks about things that are or are not unequivocal invocation of counsel. So saying, I think I might like to talk to somebody, or I want to talk to somebody, or do you think I need an attorney, or can I have an attorney? Those are all unequivocal, just as saying, I'd rather have an attorney, are also ambiguous and equivocal. But regardless, as a finding of fact in the suppression journal entry, the court found that the law enforcement officers terminated the interview. And that is supported by the transcript. And a motion to suppress evidence presents a mixed question of law and facts. If the record supports the facts, then they should be accepted as facts. In this case, the suppression hearing transcript shows that Sergeant Looney testified that they interviewed Ford on May 23rd, 2017. They advised him of his Miranda rights at the beginning of the interview. At one point, they believed Ford said, I may have to talk to counsel, which was their recollection of, I'd rather talk to counsel. And then Sergeant Looney said he advised Ford of the charges, but Ford kept talking. So the transcript supports the findings of fact that were made by the court. Of course, the conclusions of law are de novo. So the court found that...
Relative to that, counsel, on the, there's a transcript of audio recording of the interview, correct?
Yes.
And the trial court, when ruling on the motion to suppress, had the transcript or had the audio actual recording, or both?
I believe the audio recording.
Okay, and
I would have to go back and double check on the transcript. I apologize.
I think, okay, I appreciate that. And in any event, do you know if the audio recording and the transcript is in the record?
They are in the record, to my recollection. Both are in the record.
Okay, thank you very much.
And I apologize, the record in this case is very voluminous, and the trial started once and then restarted, and I don't want to misspeak, so I apologize for that. So the detective stopped questioning, and then Ford reinitiated the conversation, continued to speak freely, talked about what is going to happen to me now, and that is very much on par with Oregon case where they talked about reinitiating the questioning when the defendant wants to know what's going to happen to me, what's going to happen next. So based on the record, the state would argue, one, that the defendant did not ambiguously and unequivocally invoke the right to counsel, but nonetheless, law enforcement did stop questioning. The state would argue that the defendant then initiated the conversation, and under Edwards versus Arizona and State v. Tench, which is very similar as well, where a defendant continues to talk and continues to ask the court, what's going to happen, and then talks about, in that case, his mother's death, which is the subject of the interrogation, that at that point, the police can continue the conversation. Based on the record, the state would ask the court to find that the trial court properly denied the motion to suppress, and even if this court were to find that there was error, the error would be harmless because he does not actually confess in those statements, and there is overwhelming evidence of guilt with regard to the two arson-related incidents that he was convicted of. With regard to the joinder issue, the evidence there relates to the 3 fires. The joinder is obviously preferred. The defendant has the obligation to show prejudice. He does not show prejudice here. He just argues, well, I was convicted of both, therefore there must be prejudice. That is insufficient. Even if this court were to find that he was prejudiced, the state can overcome an argument with regard to prejudicial joinder by showing that the evidence was simple and distinct, and or that there was other acts evidence that was properly admitted. In this case, before Hartman was decided, the trial court had a 404B motions and responses that were filed and ruled on that. Specifically, the trial court was aware that the state was seeking to introduce the 3 incidents as evidence of plan, modus operandi, and identity. So that complies with Hartman. The specific types of 404B evidence were articulated to the trial court. Those were the reasons that the fires were all tried together. Clearly, there was similarities in the 2 house fires as well as the vehicular fire. The first house fire on Folds, 2 people died after there was accelerant on the porch, and that one of the people in the house had a history of disagreement with Mr. Ford to the point that a neighbor had put a security camera on their house so they can keep an eye on things at the decedent's house. The vehicle fire, the person who owned the vehicle had an issue with Ford, and then finally the last fire, which also started outside on the porch, that person also had an issue. One of the children in the house was Mr. Ford, and again, all 7 people in that house died as a result of the fire, all in close proximity to the home where Mr. Ford lived and where his mother lived. Just really briefly, I know I'm almost out of time, with regard to the information that was introduced by the fire marshal, I would just note, first of all, the presentations that were a video or a PowerPoint, those are basically permissible under evidence rule 1006. There was voluminous evidence in this case that was put forth into this video, and there was no objection to that video being used with regard to 719 Folds. With regard to 693 Folds, the only objection was based on slides 99 and 101, where Mr. Barkhart talks about what he saw, like I saw movement. And the court instructed the jury with regard to 693, you'll decide what's on the video, you're the decider of fact. There was no objection to the timeline on 693 Folds, and that's on page 3,694 of the transcript. The court instructed it was demonstrative only. With regard to the timeline on 719 Folds, the court had a discussion about the timeline. The only objection was to the alarm.com information, which, by the way, there's just one notation on that timeline.
Counsel, if you could close.
Yes, so I would argue that their objection is not properly preserved with regard to the evidence that was submitted through the fire marshal. Based on the evidence that was presented and the argument here today in the brief, the state will respectfully ask that this court affirm the convictions for Mr. Ford with relation to the 9 deaths due to arson. Thank you very much.
You'll have your full 2 minutes.
Thank you. The state argues that nothing in the record supports that Mr. Ford had delusion, but that's not true. We have testimony from Dr. Swales, a neuropsychologist who evaluated Mr. Ford for purposes of the motion to dismiss his death specifications. He was not performing a competency evaluation, but he highlighted in his testimony and in his report that he had concerns about the conspiracies and the potential delusional thinking that Mr. Ford exhibited during that conversation and that evaluation. He also highlighted a lot during his testimony the fact that Mr. Ford perseverates. He focuses on topics and in such a way becomes so fixated on topics that he often cannot leave a topic or focus on anything else. And so that's part of the component. Can he assist in his own defense when he has an inability to shift focus or to think of other things or to consider other things when he becomes so fixated? And that's something that Dr. Wood also noted. So Dr. Swales, the neuropsychologist, Dr. Wood, the court's own diagnostic psychologist, brought up this information. It's also present in his pro se motions where he alleges fabrication of evidence and in his jail calls. Dr. Wood here is equally experienced and raised concerns about his ability to assist in his own defense. And I asked this court to look at that and to find that the trial court in this case, in the most serious types of cases, Mr. Ford was facing death. He luckily did not receive death, he received life without parole, but this is the type of case that highlights why it's so fundamentally important to ensure that things are done correctly. And here, the trial court had options. The trial court did not seem to accept Dr. Edwards' assertion that he was competent without more. The trial court could have asked Dr. Edwards to go back and re-review all of that collateral information. The trial court could have ordered another evaluation after hearing Dr. Edwards' testimony. I'd like to briefly respond to the state's thoughts about the State v. Huff case that I supplied as supplemental authority. The reason I provided that to the court is that it goes to remedy. The remedy in that case is when because competence has to be contemporaneous, a remedy on a competence issue would be remand for a new competency determination and then a new trial, rather than a retrospective competency determination. And I would also like to turn back to the suppression issue. Police did not stop questioning. I know the state repeatedly says the police stopped the interrogation. Mr. Ford was the one who reinitiated. But as I previously argued, every single time Mr. Ford said, "I'd rather have counsel now," which Detective Looney said, I took that to mean that he wanted an attorney. Every single time, the detectives responded in some way. Do you have my card? Read him his rights. I'll be here if you want to talk. I really want to talk to you. At one point, one of the detectives says, I don't know how long you're going to be here. I'll just sit here. And so these are the things that were said to Mr. Ford. He did continue engaging and answering questions, but the problem here is he had invoked his right to counsel. A reasonable officer determined that he had invoked his right to counsel, and they were the ones who continued. And they never left the room. They never indicated they were going to leave the room. They never gave Mr. Ford an opportunity to reinitiate because they never disengaged.
Did the trial court find that was unambiguous?
That was,
That his statement, "I'd rather have counsel," were a unambiguous request for counsel?
No, they found that it was not an unequivocal request. However, based on, I think that that conclusion was incorrect because we have a reasonable officer here who gave us his perspective and his belief that that was a request for counsel, and he stated that he was going to treat it as such, but unfortunately did not. Unless there are any further questions, I ask this court to reverse and remand Mr. Ford's convictions.
Any questions? Thank you. Thank you both for your presentation. The court will take the matter under advisement and issue a decision in the case in due course. The clerk of courts will mail that decision to you on the day that it is released, and the opinions will be posted on the Ohio Supreme Court website.